Good afternoon, good morning, good evening, good whatever. If you're not on this planet, not legal advice, like, subscribe, share, comment, let your dogs and other pets watch and plants. Good morning. Hope you're all well. Wanted to briefly talk about the status of the litigation involving Tesla in Delaware and recent filing by Tesla, explain what they did and what they're claiming, just so we have a clear understanding. And it's really the defendants and Tesla joined. Of course, before I do that, as I usually do, why did the Labradoodle not make money as a lawyer? Because he only took pro bono cases. What do you call a priest who becomes a lawyer? A father-in-law. And what is a PI attorney's favorite dessert? Of course, a tort. Anyway, so last Friday, I believe, there was an opposition that was filed, or actually supporting papers that were filed by the defendants with regard to the ratification issue, and that's been raised before. So we have an ongoing legal proceeding. We are about to have a hearing on the attorney's fees. Prior to that, Tesla's counsel raised the issue of ratification. That's now being briefed. Tesla just filed a brief about ratification. It was released, I believe, yesterday, even though it was filed previously, but there's a process which by there may be some redaction, etc. Anyway, they filed a brief. It was quite lengthy, I think about 55 pages long. That position was joined in by Tesla itself. This particular brief was filed by the actual defendants. And kind of to summarize what it said is, it basically asked the court to enter a judgment for the defendants. So to completely change the judgment. And the way they got there is they cited two Delaware rules of procedure. One's Rule 54B, one's 59A. One says that before a judgment is final, and it won't be final until the attorney's fee award is decided and entered, that there can be changes to the judgment. So they assert that that's one rule that will apply. The other rule is 59A, which says that you can reopen a case to provide new evidence. So they're claiming, the claim is of counsel, that new facts have arisen, those facts being the ratification that occurred on June 13th. Either the case should be reopened for testimony to put that on, or the judgment itself should be changed. And I think that would be their preferred method. And they would like the judgment to be changed from ruling in favor of plaintiff to ruling in front of defendant. And the basic reason they state that, and the rationale in those really exciting 54 pages, is they say that Delaware permits ratification. There's a statute, I think it's section 204, that actually permits ratification to basically clear up issues with regard to authorization and other defects. And the counsel says you can use that section, as the shareholders have, in the ratification process to clear up any defects in that process. So that's one aspect. Another aspect they say was that in making the decision as to what the burden of proof is and who had the burden of proof and what it was to be reviewed as, and recall the court found that Elon was a controlling shareholder. Because of that, the burden of proof got flipped from the plaintiff to the defendant, and they used a certainty or fairness, the entire transaction standard, which is a much more rigid standard than a business judgment rule, which is basically if someone exercised due care and good faith, that's sufficient. So they imposed the standard. So here what they're saying is Elon's not a controlling shareholder. He didn't have control over the issue. Everybody was fully informed. Everybody could vote on the merits. Everybody was exposed to all arguments related to it. And as such, and because he was not controlling the transaction, and because he actually had a smaller percentage of interest in his shareholder interest in Tesla, therefore he was not a controlling shareholder. If he was not a controlling shareholder, then as opposed to the standards they use, they should have only used the business judgment rule, which certainly would have passed muster. In other words, the pay package would have survived. They also focus upon the fact that they said one of the important facts about why ratification should be accepted and adopted here is because of compliance with a case called MFW, which basically laid out ways of making sure that these type of situations resulted in fairness to shareholders. And what the attorneys point out to in this particular case is that Tesla hired a committee or had a committee of experts who met like 16 times or something, spent a lot of time figuring out what was appropriate. They are the ones who ratified the ratification. That, they said, provides fairness and objectivity. On top of that, they also add that all these shareholders could vote on the merits and were fully exposed to all the facts. And in light of that, the ratification is now supported. Now, what's important about that is the ratification was supported and the decision was upheld. The attorneys say then the proper way of reviewing it at that point in time, because the transaction would be completely cleansed, would be the business judgment rule. And all you would have to do is have the directors exercise some level of due care and good faith, and that would withstand scrutiny. And in this case, I think the actions of the board would withstand scrutiny, especially in light of the committee of experts who made recommendations to them. They also say that the only way to get around the business judgment rule, that very low standard, is if there's waste. In other words, if the shareholder was giving his family shares for no reason under the table. But if the person's providing value, there's really no way you could have waste. And if there's no waste, then the business judgment rule would be the standard and would stand. In other words, then the ratification that occurred with the committee, with full notice, with the full facts, would not only stand up, but also would flip the analysis in the court. And based on that, the court should enter judgment for Tesla and the defendants and not for plaintiff, because when you look with those new standards, you would come to a different conclusion. On top of that, they would say is that if you looked at it and the burden shifted because of the ratification with the full notice and use of committee, that the plaintiff couldn't meet the burden of proof for the entire fairness review. So in light of that, the court says, or excuse me, the attorneys say, therefore, judgment should be entered for defendant and the ratification should be honored and we should move on. That's kind of a summary of the argument. And again, the key facts or the key factors that Tesla focused on, actually it's the defendants, like the directors, not Tesla, was the committee, its value and its work, and then how the shareholders, what they were provided, their ability to make a decision on the merits, disclosure of all the information, the burden shifting and changing back to a more normal situation, and there be no waste. And in light of that, they say enter judgment and we move on. So the next step will be there'll be a hearing on July 8th. Now we go back to the attorney's fees, because the court set basically two hearings. One of the attorney's fee hearing, which is on July 8th on the motion for attorney's fees. And the second one will be on this matter, what's the impact of the ratification. And there will be another brief, at least one more brief filed by the plaintiff, who will oppose this brief, I'm sure. We'll find arguments to oppose this brief. And there may be a reply brief after that, and then there'll be a hearing. There's no date yet set for that hearing. That would be on ratification. And I don't know if the court will issue a ruling on the attorney's fee motion before we have a hearing on the ratification. It would be interesting. It's an interesting choice how to do it. But we will see. Keep you apprised as other events happen. Be well. Take care. Have a great